Hello, this is the Civil Liberties, Section C, Civil Liberties, Rights of the Accused lecture. Our prioritized standard is Government Civics number 15. Objectively, we're going to evaluate the balance between due process protections and government restrictions against it. The Fourth Amendment states that police cannot search for evidence or to seize either evidence or people, meaning arrest you, without a proper warrant obtained with probable cause, which is a reasonable suspicion of a crime. So this kind of shows you where that fits on the continuum. No info, nope, can't do it. Hunch, I feel like I got it, can't do it. Reasonable suspicion, nope. Reasonable grounds, nope. You have to have probable cause in order to seize property or get a search warrant to be able to seize that property. In Mapp versus Ohio of 1961, in a 6-3 decision, if you love your margins, the exclusionary rule was created, stating evidence obtained by illegal searches and seizures was inadmissible in federal and state courts. But the police do not always need a warrant to seize evidence or arrest persons, though. When police make a lawful arrest, they do not actually need a warrant to search a suspect for a weapon. Why? Well, they might have a weapon to assault the cop, so they have to make sure that they won't be assaulted. Also, if the evidence is in plain view, a warrant is not necessary. So like if a cop can see an illegal action through an open window, they don't have to stop and go get a search warrant. They can just arrest right then. Also, vehicles, things like automobiles, boats, airplanes, they can actually be searched when there is probable cause without a warrant, because that is a movable scene of crime. So if they waited to get the warrant, it might be gone before they had an opportunity to get back. Schools require a lesser standard for searches than police officers, like was illustrated in the New Jersey versus TLO of 1985 case. Now, if you're curious what the TLO stands for, I couldn't tell you, because that person was a minor, so we only have their initials. So in this case, a student caught smoking had her purse searched, which then found marijuana and a list of drug sales. The student claimed the search was an unreasonable search, but the court ruled in a 6-3 decision, if you love your margins, that based on being caught smoking, the school actually had a reasonable suspicion to perform the search. So a lesser standard than you would see out of the police, in other words. The 5th and 14th Amendments guarantees the government cannot deprive people of life, liberty, or property without due process of law, meaning that they must act fairly and in accord with established rules in all that it might do. Due process actually governs police power, which is the authority of each state to act to protect and promote public health, safety, morals, and general welfare. Police officers may only sidestep a person's due process if there are reasonable grounds, like drunk driver refusing to submit to a blood test. Well, yeah, they don't have to give you due process. They can just take you in. Police officers may not use unnecessary force, however, when they enforce a criminal law. So you can use enough force, but it can't be excessive. The constitutional guarantees of due process have actually created a right of privacy. So if you look in the Constitution for a right to privacy, you're not going to find it. Best case, you might find the 9th Amendment that says you have other rights. But Supreme Court's basically determined that you actually do have a right to privacy, with Roe versus Wade of 1973 being a landmark case in providing medical privacy rights. The court ruled in a 7-2 decision, if you love your margins, that the decision to have an abortion was actually a private matter between a woman and her doctor. Abortions could not be restricted during the first trimester, so first 3 months, but could be restricted when the fetus reached what they considered a point of viability. And at that time, they said that's usually around 28 weeks or 7 months, but possibly as early as 24 weeks. And more currently, viability is reached earlier and earlier. The 5th Amendment also guarantees a right against self-incrimination, which is the right to not be forced to be a witness against oneself. This right guarantees that the burden of proof is always going to be on the prosecution, so they can't have their case solely based on things you say. They have to have other evidence. Now, I should point out, before you start pleading the 5th, This cannot be invoked when testifying against someone else. So if you don't want to get one of your buddies in trouble, you don't actually have a protection to not talk in that circumstance. Also, when your testimony could not lead to a criminal charge, so if there is no possibility of you going to jail for whatever action you did, you can't plead the fifth for that also. And another kicker, it's actually up to the courts to decide when the right can properly be invoked. So you might feel like you have a right to the fifth, to plead the fifth and not talk, but it's up to the court to determine if you do in fact have that right. All right, so there are the different burdens of proof. In Miranda versus Arizona of 1966, the court determined in a 5-4 decision, if you love your margins, that accused must be informed of the following rights at the time of their arrest. And if you've ever watched Cops, Bad Boys, What You Gonna, you probably already know all these rights, which include a right to remain silent. Also, anything they say can be used against them in court. They also have to be informed that they have the right to have an attorney present during questioning. Also have to be informed that if they cannot afford an attorney, one will be provided at public expense. And also, they may bring police questioning to an end at any time. So they have to be informed of these rights and then have to acknowledge that they have been informed of those rights before they can actually question them. Also, the Fifth Amendment provides for a grand jury, which is a formal device by which a person can be accused of a serious federal crime. Most serious state crimes do have grand juries, but that's not guaranteed as of this filming. And also a protection against double jeopardy, which says once a person has been tried for a crime, they cannot be tried again for the same crime. And if you don't want to have double point values, I guess. The Sixth Amendment guarantees the accused rights during the trial process. For instance, it guarantees to a speedy and public trial by an impartial jury. Speedy trial ensures that the government will try a person accused of a crime without undue delay, although if there are valid reasons for a delay, that's not actually a violation. Also, a judge can limit the number and kinds of spectators that are present at a trial. So while it's a public trial, they might determine that, well, we don't want the media to be there, and they can actually ban the media if they feel like it's not to the benefit of the accused. Also, jury trials only guaranteed in cases of serious crimes, and it can also be waived by the defendant, so you are not forced to have a jury trial if you'd rather have a bench trial. A defendant also has the right to be informed of what they're being accused of, also a right to confront and question witnesses against them. They also have a right to have witnesses that can be questioned in their own defense, and they also have a right to have the assistance of an attorney, even if they cannot afford one of those attorneys. And the case that made that so is in Gideon versus Wainwright of 1963. The court determined in a 9-0 decision that the right to a lawyer extended to state felony cases, even if defendants were unable to afford their own. So this man had to go to prison so that you could actually have that right. The Eighth Amendment provides protections against certain types of punishments. For instance, it protects against excessive bail and fines. Now, bail is usually set in accordance with the severity of the crime. So the more severe the crime, the higher the bail. So if it's a speeding infraction, very small bail compared to committing murder. A suspect can be held without bail, but there must be good reason to do so. For instance, if there's a high likelihood of being a flight risk, or if they're likely to commit another crime, they can use what's known as preventative detention, so they put you in jail before they actually have tried you with anything. It also forbids cruel and unusual punishment, preventing barbaric tortures like burning at the stake and also crucifixion. Yet, it is actually deemed capital punishment, which means punishment by death, to still be constitutional. So you can have the death penalty as long as it's a part of what's considered a two-stage law, with a trial first, followed by a sentencing hearing afterwards. Now, I should point out, even if you are sentenced to death, all prisoners cannot be denied medical care. They basically determined that to be unconstitutional to deny prisoners of medical care, which might lead to the question of, well, why do regular citizens not have to have medical care? And additionally, the original provisions of the Constitution guarantee several rights for those accused of crimes, including a right to habeas corpus, which we've talked about previously, which enables a person accused to challenge arbitrary detention and force an open trial before a judge, and protections against bills of attainder, which are legislative acts inflicting a punishment without a court trial, and also ex post facto laws, which would be laws that make acts a crime after those acts have been committed and working to the disadvantage of the person being accused. And all of these things we talked about are a part of our system because we operate our courts under the assumption that people are innocent until proven guilty by a fair and lawful means, which is not the case in other countries. All right, this concludes Civil Liberties, Section C. Civil Liberties, Rights of the Accused. Our prioritized standard, again, was Government Civics 15, and objectively, you can evaluate the balance between due process protections and government restrictions against it.